Incorporated, represented by John Oliver. John seated down at the end of the table from Cape Girardeau, and David Collins from Macon, Missouri, seated kind of in the middle there next to Fred. These are experienced trial lawyers, I'll tell you, as of we worked together yesterday, and I'm impressed with how quickly they became knowledgeable about this case, and I'm impressed with a lot of things they had to say about it. We're going to do what will really amount to an abbreviated, to a large extent, voir dire. I'm going to be a plant juror and give them some of the key responses that you normally expect to get about previous injuries, about being a defendant in a lawsuit previously, and things like that. So that will be set up to be, but we think that we all agree that the responses that I'll give will be fairly typical of the kinds of responses you get with a complete jury panel at your voir dire. So with that, gentlemen, I think we're probably ready to begin. I have somebody's microphone. I'll turn it over now then to Judge Connery.
If this were a real case at this particular point in time, the court would probably do some voir dire if it were in my court. In some courts, the court never does any voir dire, but basically, in our court, we do conduct the first part of the voir dire, and then we give the attorneys an opportunity. We're going to dispense with my questions, which would be of a general nature to the jury panel, and move right into the voir dire by the plaintiff and defendant. Inquiry by the plaintiff. Mr. Kester.
Thank you, Coach.
We got four.
Let me carry that with us.
I know you got one. I'll just take this.
Y'all are tangled up out there.
May it please the court,
Mr. Kester.
ladies and gentlemen of the jury. At this time, and before you folks get to hear any evidence in this case, we're going to pick a jury called a voir dire examination. We do not actually pick a jury as such. I cannot, and I do not have the opportunity to say to you, I would like to have that juror, or that juror, or that juror. It's really a process of elimination. 18 of your number are called down, and each lawyer must take off 3 names so that your number is reduced down to 12. To those of you who are not chosen on this jury, do not take that personally. Many times, our selections are made without any reason or cause whatsoever. You are all generally qualified as jurors, or you would not be here. But on the other hand, sometimes there is a reason. You may have had an incident similar to the type of incident that's going to be tried before you. You may have been treated by the doctor who's involved in this case. You may know one of the parties involved. You may not want to sit on this jury because of your experience or knowledge or background or education or exposure to this kind of a fact situation. I'm not going to pry deeply into your backgrounds, your personal affairs and matters, but I'm going to ask you some questions that I believe might relate to your mental attitude and your thinking and how you would handle this fact situation. I'm going to try to get a fair juror, a jury that has an open mind, a jury that can hear this case and be fair to both sides. Obviously, if you have preconceived notions on who's right or wrong or liability, you couldn't possibly be a fair juror to one or both sides. I'd like to introduce the parties that are going to be involved in the case, and then I'll tell you a little something about the case. Now, on voir dire examination, when I select a jury, I can tell you basically the kind of case you're going to hear. I can tell you what it's about, but I cannot go into detail. And at the time I make an opening statement, I'm going to tell you in great detail what happened. But at least I'm going to tell you enough at this time so that you know the kind of case you're going to try, so that you can make a determination of whether you've been exposed to this kind of an experience. First of all, the plaintiff in this case is Mary Lou Scott, or Mary Sue Scott. Mary Sue will be here shortly. She said she'd make it by 10 o'clock. Unfortunately, she had to be in the doctor's office for therapy treatments this morning. There will be some witnesses that will testify in this case, and I want you to understand this. There's a clerk who was working in a booth, and her name is Mary Clark. There's also a records supervisor named Joseph Arnold. They were both employees of the defendant in this case. But I want you to understand at the outset that we didn't sue these little people. We
Objection,
sued
Your
the
Honor. He's arguing his
corporation
case
only.
now.
We sued the corporation. They are merely employees of the
Objection, Your Honor.
corporation.
He's continuing the same line of argument.
Objection will be sustained. Proceed.
The defendant in this case is the Supermarket Incorporated of Lee Summit, Missouri. So first I'd like to ask you, do any of you shop there? Have you ever been employed there? Do you own a stock in that corporation? If I don't see you raise your hand, I'll assume that your answer is no or negative. Yes, sir.
I've shopped at the supermarket store here in Columbia. Is that what you want to know?
All right. Are you familiar with the south entrance of that supermarket?
Let's see, which way is south? Yes, I think so.
That's the opposite of north.
Oh, yes, yes, sir. With that in mind, I am.
Have you had occasion to use the treadle in the entranceway?
That's the door toward the parking lot. Yes, I've gone in that door.
And on the occasions that you've gone in, have you ever gone in to that entranceway when there was a carpet, red, blue, green, or any other color at the end of the treadle to sop up the water that might be tracked in?
I don't really remember whether there was a carpet or not.
Okay.
I just go in, whatever's there is there.
Okay. Do you remember if you ever entered on rainy days?
I don't remember that.
All right. Well, at any rate, you never fell going in the entranceway, did you?
No, sir.
And you never slipped on any water on the occasions you went in?
I don't think so.
Okay. Well, you'd remember that probably if you did.
Yeah, I think so.
Okay. Before I get off into any other individual questions, I'd like to introduce the people that are involved in this case. As I said, Mary Sue Scott is the plaintiff. I expect that a witness will testify probably for the defendant, who was a clerk working in a booth, and her name is Mary Clark. Do any of you know Mary Clark, or if you've ever been in that supermarket, have you ever seen her as an employee in that store? I take it by your silence and the fact that you haven't raised your hand that you have not. There's another employee of the defendant who has a title called Records Benefits Supervisor. At least that's what he called himself when we took his deposition, so that's his official title for this corporation. And I expect that he's going to testify, and his name is Joseph Arnold. Does anyone know him? I expect a Joanne Stewart, who is the clinic office manager for a Dr. Durnell, who at some time in the past treated the plaintiff for a condition of bursitis of her left hip. Does anyone know Dr. Durnell or Joanne Stewart? Okay. Is there any member of this panel who is employed by or has any financial interest in the State Farm Mutual Automobile Insurance Company? Anyone at all? Yes, sir.
You mean, am I insured by them?
I'll have to refer to the court for a reply to that, Your Honor. I don't believe I ought to go any further with that answer. Do you have any response to that question, or shall I move along?
Yeah.
Thank you. Thank you very much. I can't respond to that question.
Okay.
Okay. According to the law of this state, if someone is injured because of someone else's alleged negligence, whether it be an automobile accident or, as in this case, a fall in a store, the defendant, through their lawyer in that case, can hire their own doctor. They pay for that examination. They pay for the x-rays.
This is argument and not voir dire.
Objection will be sustained. Proceed.
An examination was made by a Dr. Joseph Smith. I expect Dr. Joseph Smith to appear here and testify on behalf of the defendant relative to his findings and relative to his examination. Do any of you know Dr. Smith? Have you ever been treated by Dr. Smith? Or have you ever seen him in court here testifying for the defendant on other occasions? I take it by your silence that you have not. This suit, I filed this suit for an amount, and the defense may tell you you can sue for any amount. I've tried to keep the amount of this prayer within the limits of reason. And I have asked in the prayer for $300,000 as being your verdict after you hear the evidence, and I expect the evidence to support that amount. Is there anyone on this jury who, because of that amount of money, regardless of the evidence and regardless of the injuries and regardless of the disability, you feel that you just could not and would not bring that amount of money in for a serious knee injury? Or some reason of your own, whether it be a religious conviction, a personal conviction for a reason known only to you. I take it by your silence that all of you feel that if the evidence supports it and you believe those injuries are as severe as I will prove them to be, you could bring that amount of money in. Anybody feel differently here? Thank you very much. The facts of this case basically are that on June the 17th, 1977, at approximately 5:30 p.m., the plaintiff, Mary Sue Scott, entered the south entrance of the Supermarket Incorporated door. That it had been raining outside and that other customers had tracked water and puddled water just beyond the end of a treadle which opens the door automatically. And that as she took about one step forward, she stepped into some water which she saw as she got over the top of the water, she could see.
Counsel's arguing objection to be overruled.
As she got over the water and as she tipped forward, there was a puddle of water. She couldn't pull herself back. She stepped down. Her left foot went out from under her. She fell down, buckled her left leg under her, and her body weight dropped down her left knee. She broke her knee, which was subsequently surgically removed. The kneecap was taken off. At the time that that accident occurred, there was in the store manager and the store clerk, as I've already indicated, and I expect...
Your Honor, this is an opening statement rather than voir dire.
Objection to be overruled.
I would like to ask you members of, first of all, I'd like to ask you this. Has anyone on this panel ever had a suit filed against them? Now, before you raise your hand, I'm not interested in your personal affairs. I'm not interested in whether you were involved in any business litigation or matters unrelated to someone being injured. I want to know whether anybody's ever had a suit filed against them or your immediate family living in your same household wherein some person has claimed that because of your negligence, meaning your fault, you have caused and produced an injury to another person. Yes, sir. You seem to have all the questions here. Have you had a suit filed against you?
Yes.
Did that arise out of an automobile accident?
Yes.
Was that a rear-end type collision?
Yes, it was.
Was the party that sued you, were they hurt?
She said she was.
Wait a minute. I didn't get that last answer. She said she was?
She said she was hurt, even though she told me at the scene she wasn't.
I take it from that answer that you don't believe that she was hurt.
I didn't think she was hurt.
And you still don't believe she was hurt, do you?
No,
Nothing's changed your mind since then, has it?
not really.
So basically, do you feel that an illegitimate, or some people call a phony, claim was filed against you?
I don't know if I can say that here in court, but I can say that I thought so at the time.
You haven't changed your mind since then, have you?
Well, not really.
All right, the reason I'm asking is I don't want to get too personal with you, but if you feel that somebody sued you when they didn't deserve it, when they didn't deserve the money, and they collected some money, didn't they?
Yes, sir.
You believe that they were unjustly enriched, don't you?
Well, yeah, I personally
All right.
think so. I guess my lawyer did.
Taking that into consideration, that somebody sued you with a claim you believe to be illegitimate and got money they did not deserve, do you feel that you could sit on this jury and listen to my client's personal injury case where she's asking for $300,000 and the defense is saying the same thing as the defense said in your case? She's not hurt seriously. It wasn't their fault. Do you think that might influence your ability to be fair in this case?
I hope not, but I can see the point.
You say, I hope not. Could you make me feel a little more comfortable? Could you say, I'm sure I could do that?
It would just have to depend on what I hear about the case. I don't know.
Well, what I want to know from you is this. Because of that incident, just that incident, forget about the facts of this case for a minute, do you think that that incident might carry over into your thinking, your deliberations, and how you would award money, or the amount of money you'd award, or the liability or fault in this case?
I'm suspicious about how this system works.
I'm a little suspicious about your answers, too.
I don't know. I just don't
You're
know.
just not sure.
I'm really not.
I appreciate your candidacy, and thank you very much. Is there any member of this panel who has ever had a workman's compensation claim, that they made the claim? You have had that?
It was a legitimate one.
This one, there was really an injury.
Right. My neck still hurts.
Were you sent to a doctor for an examination and a disability rating?
Yes, sir.
All right. And then the doctor, did he rate your disability at a percentage?
I remember him talking about a percentage, but I'm not sure what that means. Really.
Now, was that a back injury?
Yes.
All right. Do you understand that under workman's compensation, once that percentage is arrived at, there's a limit on what you can recover? You understand that?
Yes, that's what I
That's
was
set
told
by
my
step.
lawyer.
Okay. Do you also understand that you cannot recover any money for your pain and your suffering that you went through till you reached the point of maximum recovery?
Yeah,
You
I
understand?
think I understand that.
All right.
Didn't get much money.
But conversely, I understand, and that's why I don't want to happen here today. But conversely, do you understand that in this kind of a case, if you find that this woman had pain and suffering, that she walks with a limp, that she's disabled for life on a permanent basis, that you can not only award her money for that permanent injury, that disability, that limitation of motion, that limp, but also for the pain and the suffering and the misery that she's gone through already, up to date, and for the rest of her life. And that's unlike workman's compensation relative to pain and suffering. Do you understand that?
If you say so, I'll take your word for it.
Okay, sir. Now, how many of you folks are property owners? Okay. Is there any member of this panel who has ever had someone fall on your premises or in some way sustain an injury on your premises where they have made a claim against you, claiming that you were negligent either in permitting debris or your property to accumulate or your property to become in disrepair? You've had that, have you, sir? Okay. And was there a suit filed?
No, there wasn't suit filed. It was settled.
Was there a claim made?
Claim. Yeah, I guess there was a claim made.
Did you pay that claimant some money?
I didn't. I'm sure.
Objection, Your Honor.
I didn't get your last answer.
Sorry, he did.
Please further back. Now, I'd like to inquire into some of your job classifications. First of all, are there any members of this panel who are store managers or store employees responsible for the maintenance and the repair of the store premises relative to the use by customers? Okay, yes, sir.
So I used to be an assistant manager at a discount store, a fast food place.
All right. You were an assistant manager.
Yes, sir.
As an assistant manager, was it your job, number one, to keep the floors clean?
That was one of my duties, yes.
Okay. And if the floors were not kept clean and someone fell because of debris or uncleanliness or disrepair, did the burden of that responsibility fall on your shoulders?
That among other things, sir.
Okay. And has that store ever been sued because of some problem with the floor disrepair or debris where you came in and testified for the store?
No, sir.
Have there been claims made where you were involved in the investigation?
No, sir.
Did you have the responsibility of taking statements and acquiring information from the injured person when they fell and then reporting that fact situation to the company?
No, sir. My superiors handled that.
Okay. Did you participate in obtaining that information so that they could make the report?
No, sir.
All right. Have you ever been criticized by your employers because of any condition of the floor that someone was injured on?
No, sir.
Do you think you should have been?
Oh, no, sir.
No. Did anything ever happen, really what I'm asking, did anything ever happen to a customer and fall on the floor, to your knowledge and in your presence, where you participated in finding out or investigating the cause?
No, sir.
Okay, thank you very much. Anyone else? Yes, sir. All right. In this case, you were a clerk. In this case, and we've taken the depositions of the clerks and the employees and the store manager, so we pretty well know at this point what they're going to say. And I expect that they're going to say that everybody in a store, the clerks and the managers and the employees and the people behind the counter, all shared the duty and the responsibility of seeing that the floors were kept clean. Was that a fact at your place of business? All right. Would it be fair to say that if a manager patrolled the store and he didn't see a watery condition and there was a lady behind the counter and she did, it was her responsibility in your store to get out and clean it up?
Or to send someone.
Pardon me?
Or to send someone to clean.
Okay. And in your store, did you have a manager that patrolled the store? And I'm using the word patrol because I believe that word was used in the testimony, in this case, in a deposition. Did you have a man that patrolled the store just to see that the water and debris and accumulations of whatever might occur are kept removed? Okay. And were you ever involved in a case where there was a fall and an injury? Did you ever see that occur? What did the person fall on? Food on the floor.
Mr. Kester, about 2 minutes.
Thank you, Judge. And in that case, was there a suit brought? Was there any claim made? Okay. Do you have any feelings about anyone making a claim against the store because they fell on a store that contained water or debris? Do you feel that would make any difference in your deliberations because of the job you had? Okay. The court has indicated that I got 2 minutes. I won't go into all of these questions, but I would like to tell you that the kind of questions that I would ask of the jury in a fall case would be, I would inquire as to the kind of occupations where the jurors might be most likely to get sued or be involved in litigation. So I would ask if there was anybody that's a realtor who has a business of maintaining premises. Bus drivers and cab drivers routinely get involved in litigation because they're operating the vehicle with the public on, and they usually have to give depositions after a suit's filed against those companies. Apartment managers are terrible in these kind of cases because they always get blamed if somebody falls in an apartment and it hasn't been kept and maintained. Property owners, of course, are always a bad juror in this case, but you can't always get rid of all of them. Security guards are in the same position. It's their job to investigate an accident. It's their job to make a report, take statements from the people, and it's their job to keep the premises clean, just like a store manager's job is to keep the premises clean. Restaurant managers, design engineers you've got to watch out for because their job is to design a product safely so that an injury does not occur as a result of their defective design. Quality control people. Anybody that has a job that is to maintain the quality and the safety of the premises that might be involved either as a defendant or as a witness for the corporate defendant would usually make bad jurors. Thank you.
Called by the defendant. May it please the court, Mr. Oliver.
Ladies and gentlemen, my name is John Oliver, and as the court has indicated, I'm here from Cape Girardeau with Dave Collins, and we represent Supermarkets Inc. of Columbia. That's the supermarket store just up the road and around the corner to the right. I want to reiterate a little bit what Mr. Kester said. The purpose of what we're doing here this morning is not to pry into your life, and I'm sure that Mr. Kester didn't intend to pry in your life. Our purpose is to acquire a jury of 12 people, men and women, who will be completely fair and impartial. That's our purpose. A long time ago in the Middle Ages, people used to settle their disputes by combat on the open field. We've long ago abandoned that in favor of what in this great country is the jury system, where we substitute the independent judgment of 12 people, fair and impartial people, to hear the facts and to determine the facts, and that's what you, or the 12 of you who are ultimately selected, are here for today. Now, everyone in this box, all 18 of you, ladies and gentlemen, are qualified. Each one of you individually is a person who is qualified to be a juror. You have all of those prerequisites that will make you a good juror. But each of you has also come to the courthouse today with your own individual background, your own education, and your own experience. Some people call those prejudices. Some people call those preconceived ideas. But each one of us, by reason of our background, education, and experience, has our own point of view. Some of those points of view may be harmful to one side or the other, or may give an edge, if you will, to one side or another in this lawsuit. And it's our purpose, and it's only our purpose by these questions, to determine if any of those preconceived ideas or those points of view will interfere with your function, which is to be a fair and impartial individual. Listen to the evidence, hear the facts from the witness stand, get the law from Judge Conley, and then apply those facts to the law. As you know, the plaintiff in this case is Mary Sue Scott. Her husband, I think, is named Charlie, and she has 3 or 4 out-of-work kids living at home with her. Does any member of the panel know the plaintiff, Mary Sue Scott? If you do, or if you have an answer, I would appreciate it if you would raise your hand. It'll make it a lot easier for us to respond to you. Does anybody know her husband? What about these 3 kids? I think their names are Charlie and Jim and Sam, who are out of work and live at home. Do any of you know them? Now, ladies and gentlemen, or any member of the panel or their immediate family unemployed and living at home with their family? Thank you. Now, the plaintiff here today is represented by Mr. Jim Kester and by Mr. Fred Wilkins. Mr. Kester is from St. Louis and Mr. Wilkins is from Kansas City. Both of them are well-publicized plaintiffs' lawyers, and they travel around the state and try these plaintiffs' cases, and they get a lot of publicity in the press. And we're here in Columbia today. Let me ask you if any member of the panel knows either Mr. Kester or Mr. Wilkins or any member of either one of their firms. Any of you or any member of your immediate family been represented by? And folks, have you read about either one of these big money lawyers in the paper? Now, I want us to take a minute and I want you to think about this, and I'd appreciate it if you would think about this for just a minute. Would the fact that Mary Sue Scott is represented by two big city lawyers here in Columbia have any effect on the way you might look at this case? In particular, would it tend to prejudice you against Mary Sue Scott that she had to go outside of the city of Columbia to hire two lawyers to take her case?
Your Honor, let me object to this. We've taken this as a charity case.
Objection will be sustained. Let's proceed.
By the same token, you all know that I'm from Cape Girardeau and Mr. Collins is from Macon. Now, my cousin is with the firm of Oliver, Wellman, and Atkinson here in Columbia. Are any of you acquainted with that firm? David's in a hospital today, and we're trying to keep the fee in the family, so to speak. Would that bother any of you, or would any of you have any prejudice or tend to hold it against supermarkets? My client, Mr. Collins' client, that we came here today, and David and I are here to take my cousin's place. Would that bother any of you folks? Now, I think we've already indicated that this unfortunate incident occurred on June 17th, 1977. It was a day pretty much like yesterday. I'm sure you all remember the weather yesterday. Mary Sue Scott on that day late in the afternoon wearing some sandals, no straps on the back, came flip-flopping into the store.
Your Honor, let me object to this. This is an open statement rather than an inquiry from the jury.
Objection will be sustained. Let's proceed.
Came into the store, and instead of walking on the red mat that we had provided for her,
Objection, Your Honor. He's going into an opening statement and an argument, and it's not an inquiry of the jury.
Objection will be sustained. Let's proceed.
thank you, Your Honor. At Supermarket, we try to be a good store. From time to time, of course, as in any.
Whether they're a good store or not, they weren't the day of this accident.
Oh, Your Honor, that's uncalled for
Let's move,
comment.
gentlemen. Let's move along.
Have any of you who have shopped there, or your wives or spouses who have shopped there, ever had a bad experience of any kind at the store? Not just some kind of fall like Mr. Kester has, but have any of you had any kind of a bad experience? Does anyone, for instance, perhaps no longer shop there because maybe you got bad vegetables or you thought you were being overcharged? Now, folks, have any of you ever shopped there, or do any of you ever shop there? Now, you know, this is a store that's right up 63, and you turn right on the business loop, and we're right there on the corner. Mr. Turley,
Yes, I've shopped there.
do you do the shopping in your family, or does your wife, sir?
Well, she does most of it, but I do have to go in once in a while and get something.
As you can recall, have either you or your wife ever been in there on a day like yesterday?
I'm sure we have. Yeah.
As you go in that south door, and I think I heard you say to Mr. Kester that you remembered the south door, that's the one from the parking lot?
Yes, sir.
Do you recall, as you go in there, Mr. Turley, seeing this red mat right in front of that rubber mat?
I don't remember one way or another, Mr. Oliver. I just don't.
Thank you. Now, folks, there's going to be some evidence today from a bunch of doctors. One of these doctors is a Dr. Sam Jones from the medical center. Do any one of you know Dr. Jones, or you or any member of your family or a good friend being treated by Dr. Jones? Thank you. There's also be evidence that for whatever reason, the plaintiff has seen every member of the Columbia Orthopedic Group. That's a whole lot of doctors. Dr. Dixon, Dr. Smith, Dr. Jones. Do any of you or members of your immediate family know any of these physicians? Mr. Turley?
I don't know who they are, that's all.
Have you ever been treated by any of them?
I think a number of years ago, maybe.
Mr. Turley, let me ask you, and again, I don't want to pry, but because you know this Columbia Orthopedic Group, would that tend to cause you to give more weight to that doctor's testimony?
I don't think so.
Do you think you could sit here today, sir, and listen to what the doctors say with a fair and open mind?
I think so.
Thank you very much, sir. Now, also today, Sam Townley will testify. Mr. Townley is a paramedic. Any of you paramedics? Any members of your family paramedics? You know, they're the ones that come in the ambulance. Let me ask you then, if you all have seen some of these television shows that portray these paramedics, like one about the firehouse or the fire station. You all remember that on television? Any of you seen those? Okay, thank you. In the back row, and let me just ask the back row, is there anything about those shows that would tend to cause you to believe that because a paramedic says something, it might be true? Or that just because they're a paramedic, that their recollection of the facts might be more accurate than someone else's? Anything about those? I guess in fairness and candor, we ought to ask the other question. Is there anything about the fact that paramedics are portrayed on television shows that might tend to make you disbelieve them? I guess we ought to ask you. I don't think we have. Does any of you know anything about this case other than reading the books that you got before you came in today? Any of you heard anything about the case? Now, one of the injuries that's going to be discussed today is a transverse fracture. It's a big word, I learned it last night, of the left patella. To us ordinary people, that's broken kneecap on the left side. Any of you ever had any knee injuries? You or any member of your family, some of your friends, had any knee injuries? Yes, sir. I see your hand down on the end. What kind of knee injuries, sir? All right, so is there anything about that disease or the process of treatment that might tend to make you more sympathetic to a person who's had some difficulty with their knee? What's your current status? And again, I don't want to pry, but are you in pain or do you have any...
No, I think I'm completely cured.
Thank you. Now, ladies and gentlemen, there's also going to be some testimony about bursitis, I think. Any of you have bursitis or arthritis? Or about some of your family? I know you're all pretty young. Is there anything about your family's experience with arthritis that might tend to give you a preconceived idea about how much pain arthritis causes?
My wife has bursitis in her knees.
Does that cause her a lot of problems, sir?
Yes, it does.
Very painful?
On a rainy day.
When the weather turns bad or cold, doesn't she suffer
Yes,
pain?
she does.
Does that cause her to limp, sir?
Sometimes.
Is there anything about, well, let me ask it this way. Would all of you agree with me that arthritis or bursitis can be a very painful situation? Would all of you agree with me, or is there anyone that disagrees that painful arthritis can cause someone to limp? All of you would agree with me with that, would you not? Mr. Turley, I hate to keep coming back to you, but you indicated that you had a previous experience in which you were involved in an automobile accident. Isn't that right, sir?
Yes, sir.
And the lady apparently said to you that immediately that she wasn't hurt, and then all of a sudden she got hurt later. Is that essentially what happened?
That's the way it looked to me.
Would you agree, Mr. Turley, that people are most likely to tell the truth immediately after an event?
I think so, yeah.
Ladies and gentlemen, let me ask everybody on the jury, is there anyone who disagrees with the proposition that a person is most likely to tell the truth, most likely to accurately recall facts closer to the event in question? Everybody agree with that? Is there any of you that have any difficulty with that? Now, folks, is there anybody that has not been in a grocery store on a rainy day? All right. Ladies and gentlemen, have any of you yourself ever slipped and either fallen or almost fallen? Is there anyone who hasn't slipped one time or another and at least almost fallen? Now, you understand, do you not, or is there anyone that doesn't understand that supermarkets, my client is accused of doing something wrong. We stand accused of doing something wrong because, according to the plaintiff, there was water in our store on a rainy day. You all understand what the accusation is? Mr. Jones, now you indicated, Mr. Manring, I think you indicated that you were an assistant store manager. Is that right?
That's correct.
Now, sir, in your store, the store manager have an obligation as part of his job to patrol the store?
Yes, sir, that's correct.
And did you think, sir, that that patrol was adequate to give the store an opportunity to find problems on the floor and stuff and get them cleaned up?
Yes, sir, I think it was.
Now, ladies and gentlemen, the evidence in this case will be that Ralph Murphy, who's seated at the council table beside Mr. Collins, is a store manager at supermarkets. Some of y'all might have seen him up there from time to time. Mr. Murphy's job included patrolling the store at 10 or 15-minute intervals. Was there any member of the jury that has a fixed opinion or a preconceived notion that a patrol or an inspection of the store is inadequate to fulfill the store's obligation with respect to checking on the floor? Any of you have a fixed idea that that's not adequate? Would every one of you agree with me today that if, in fact, Mr. Murphy patrolled the store at 10 or 15-minute intervals, that he was doing an adequate job? Everybody agree with that, that that's a fair and adequate time to patrol the store even on a rainy day? Now, ladies and gentlemen, in our system of justice, it's your function as jurors to find the facts, and it's Judge Conley's function as the judge to give you the law. And he will, at the conclusion of this case and interspersed throughout the case, give you certain instructions. And we think that to succeed in proving their accusation against supermarkets, the court's going to instruct you that the plaintiff must show that, first, the plaintiff did not know that this puddle of water was there, and second, by using ordinary care, the plaintiff could not have known of the condition. This is an experience in lawyer language. You know, one of the mystiques of lawyers, or one of the things we try to do, I guess, to keep ourselves in business, is to create our own language. Some of the words we use, and important words today, is the words ordinary care. Ordinary care is that degree of care that an ordinarily careful or prudent person would use.
I believe that the court will instruct the jury at a later time. He's going into the jury instructions, which I believe are inadequate.
Well, yeah.
Inaccurate at this time.
That objection will be overruled. Let's proceed.
Ladies and gentlemen, do any of you have a fixed opinion or even a feeling that you could not hold Mary Sue Scott to the standard of ordinary care? Any of you have any difficulty with an instruction from Judge Conley that you have to find that Mary Sue Scott, who's not here incidentally, but that Mary Sue Scott had to use ordinary care to see what was plainly in front of her? Any of you have any feeling, any hesitancy about applying that instruction? Now, folks, as you think about this, if in fact Mary Sue Scott had to use ordinary care to see what was plainly visible in front of her, and if in fact the evidence shows she saw or could have seen this alleged puddle of water, do any of you have a preconceived notion or a fixed opinion that would prevent you from finding against her if in fact you believe that in the exercise of ordinary care she could have seen this puddle of water? Thank you. Is there any member of the panel who believes that just because the plaintiff is injured, and Mary Scott is injured, there's no doubt about that, is there anyone who believes that just because she's injured and has filed a lawsuit that means she's entitled to get something? Now, another one of these lawyer words, ladies and gentlemen, is defendant. A lawsuit's a piece of paper and a $75 filing fee. And the person that brings the lawsuit's called the plaintiff, and the person that's being sued is called the defendant. That's just one of those words that the judicial system uses. Does any one of you have any feeling You know, we've been subject to television, and Perry Mason, all kinds of stuff in the press. So do you have any feeling, just the slightest feeling even, that just because supermarkets is called a defendant, that indicates that supermarkets, or particularly Mr. Murphy here, did anything wrong?
2 minutes, counsel.
Thank you, Your Honor. Now, gentlemen, ladies and gentlemen, we're a corporation. Some people just don't like corporations, and I think that's probably particularly true in Columbia, college town as it is. Do any of you feel for any reason that because the defendant is a corporation, that the defendant ought to be treated somewhat differently? That perhaps not entitled to the same fair and impartial consideration that the plaintiff might be? Yeah, thank you. I think you've already noticed 2 or 3 times in the voir dire, that's what we're doing now, that Mr. Collins and I have made objections. Trials are run by rules of evidence. It's Judge Connolly's function to arbitrate because the lawyers don't always agree what those rules of evidence are. From time to time, Mr. Collins and I are going to be making objections. It's my nature to fight, Mr. Collins' nature to fight hard for what we believe our clients' rights are, the rules of evidence. We're going to make a lot of objections, and I want to know now, before we start, if the fact that we stand up and fight for our interpretation of the rules of evidence is going to in any way prejudice you against our client. Because we stand up and object, are you going to hold that against Ralph Murphy and supermarkets? Is there any member, thank you, is there any member of this panel who does not agree with me that if you see a puddle of water on the floor, you ought to know that that's a potential danger spot? All of you agree with me that the puddle on a tile floor on a rainy day is a potential danger spot? Anybody believe that a 3x5 puddle of water right in front of you is not plainly visible? Thank you. I want to ask you one last question, ladies and gentlemen. If you were Ralph Murphy, store manager for supermarkets who's accused of misconduct here today, is there anything that Mr. Kester and I have failed to ask, anything in the deep recesses of your mind that would prevent you or in any way hinder you from sitting here as a fair and impartial juror? Or stated another way, if you were sitting on the hot seat where Mr. Murphy is today, would you want a person with your frame of mind sitting as a juror today? Thank you, ladies and gentlemen. Your Honor, any 12 of the 18 are acceptable to the defendants.
Opening statements.
And I'll use your strikes.
Somebody ought to tell them that nobody had ever really do that. All of that. Anyway. This one is this one that clips over here is real good.
May it please the court.
Welcome.
6 years, 4 months, and 18 days ago, Mary Sue Scott started in as a paying customer into the supermarket store that we've heard about. We've heard some levity. The evidence will show this is not a joking matter as far as she is concerned. She was unaware at the time she walked up to that door that not a single one of all the employees at that store had taken the time or the trouble to mop up a dangerous pool of water that was in the floor right where you enter inside the store. And in a split second, that changed her life. The evidence will show that she is the same person inside. But an awful lot of the things that she did that brought pleasure to her life have been stripped away from her because of the neglect of the store or any of its employees to remove that pool of water. These have been 6 years and 4 months and 18 days of pain for her. They have been days of limited motion in her knee. There have been days in which she has been unable to be the same kind of person she was before this happened. And these days of pain and limited motion and not being the same person are going to be with her for the rest of her life. 33 years is the average for a person her age, and our evidence of this will not be a joking matter. The evidence will touch on issues of customer safety. And by that, I mean what this supermarket and its employees actually knew about that dangerous condition, what they actually knew their responsibilities were in terms of cleaning it up so it would not be a hidden danger for customers, and that they failed to live up to that. The evidence will touch on how that neglect on the part of this corporation and its employees resulted not in a hot seat like the manager had, but resulted in Mary Sue Scott ending up in a heap on the floor so that she walked in and was carried out on a stretcher. Our evidence will show how her life has been changed by this. That day, 6 years ago, was a rainy day, on and off, and a store clerk, a longtime employee of that store who still works there, will admit to you under oath, as she has already done, having seen water on the floor where you walk in all day long. It was around 5 o'clock in the evening when Mary Scott went to spend her money in that store. The same employee will tell you what the company procedures are. And that is that every employee, not just the manager, but this clerk and all the other people who work there, are obligated, if they see water anytime, makes no difference who they are. It is their obligation to see that it gets cleaned up right then so employees do not, so customers do not get hurt, or so employees do not get hurt. The same employee will tell you that it was the store manager's obligation to patrol that store, to check that floor for safety every 5 or 10 minutes. And this evidence won't just be whether that is the obligation and whether doing that is sufficient. We'll be looking at the evidence to see whether what those employees in fact did was sufficient. This employee will tell you that she was in a booth or near the area of this pool of water all day long. That's how she saw it and knew water was there all day long. And she is also unable to tell you when she comes in here under oath of a single employee, a manager, a stock boy, anybody else all day long taking their 15 or 30 seconds or whatever it would be to mop up that pool of water. The evidence will show that the only reason mopping should be done was for safety. Mopping was done, but only after Mrs. Scott had her knee ruined, and the reason to clean it up was for safety, and that should have been done for the safety of customers before. At the time Mary Sue came to the store around 5 o'clock, it was not raining then. Her husband had dropped her off at the door. There was a covered area where she stepped under, where it was dry. The shoes she were wearing were flat and rubber-soled, and her feet were dry. As she came up to the door, her eye was caught by a large newspaper ad. We hear about big money lawyers. Let's talk about a big money store and a big money full-sized.
Injecting prejudice in the...
Your Honor, I believe this was invited. I believe this was...
Let's proceed. The objection sustained.
Thank you. This big ad was on...
We have a ruling on our motion for a mistrial, Your Honor. He's appealed the prejudice to the jury. We'd like a mistrial.
No, I'm appealing to their fairness, Your Honor.
I ask that the comment of counsel be stricken, Your Honor, and counsel be admonished to no longer make comments of that nature, obviously intended to.
I agree, Your Honor. I'll move along. The store put a big ad by the door, intended by the store for her to see that, so she would know what was on sale there and she could go in and spend her money there. As she came across the treadle going in, she could see something else they had there for her to see, which were some big carts right past that treadle, so she can buy more than what she can carry in her hands. And within a few quick seconds, because she had gone only 1 or 2 steps past that treadle, she saw then for the first time at 5 o'clock what the clerk had known had been there all day long. There was water there. She had already committed her step coming off the treadle. And within a few quick seconds, because she had gone only 1 or 2 steps past that treadle, she saw then for the first time at 5 o'clock what the clerk had known had been there all day long. There was water there. She had already committed her step coming off the treadle toward those carts. And there was no way out for her. She could not catch her balance. She couldn't do anything. She tried to do that, could not, and she crashed to the floor, landing on her knee with enough force that it shattered the bone in the kneecap to the point that all the doctors could do is go ahead and cut out all of those bone fragments out of her knee. And that, we think, is not a joking matter. Before Mary Sue Scott encountered that pool of water, the evidence will be she was in good health for a lady her age. Her left knee, which is the only source of trouble that we are here about, was a good left knee. She had not hurt her left knee any time in her life. She had never been treated by a doctor for her left knee in her life, had no trouble with motion in that knee. It was a good knee. There will be some evidence about bursitis or arthritis. Mrs. Scott, before this accident, did have a minor problem of arthritis or bursitis.